good morning to your listeners.
First of all, were you surprised by the stance of the Supreme Court yesterday?
Well, I wasn't surprised, and I don't think anybody did.
You were not surprised?
I wasn't. Because I knew it would turn out that way.
You knew?
Yes, I knew. Because the first thing that should have happened was for them to have declined jurisdiction. And once they didn't decline jurisdiction, and they issued an order to hold the status quo until they give a decision, it was clear that they were going to give it this way.
Oh, okay.
So I wasn't surprised at all. And I believe many weren't surprised at the outcome.
Okay. So for you, if they had declined jurisdiction, that would have been a separate matter.
If they had declined, yes, that would have. If they had declined jurisdiction, the matter would have ended there. Because truly, they don't have jurisdiction, and you could see that the two additional judges that the Chief Justice added to the panel, just to avoid the attack of the unanimous FT, have dissented. And I told a friend yesterday that those two would dissent. So I wasn't surprised. Those two were brought to dissent so that the judgment will not qualify as unanimous, as the Ghanaians always say. That's all.
I see.
I wasn't surprised at all.
Because per the discussions we had, the impression I got was that, per your understanding and that of many lawyers, the Supreme Court should have ruled otherwise. But you seem to be suggesting that the Supreme Court would rule this way.
Yes, you know, what you should do and what you are inclined to do are two different things. Everybody knows. Every lawyer worth his salt knows that this is not how the decision should have gone. But we also know from our experience that this is not a panel who was inclined to give a decision the right way.
A panel?
Yes.
Who were inclined to give the decision the right way?
No, they weren't inclined to give a decision the right way. They have made their motivations clear about why they were giving orders and all that. And I earlier spoke to you that those reasons are not the basis for issuing the orders they issued. And those issues even were without jurisdiction on several fronts, on several grounds. And every lawyer knows that. So they are pursuing a certain motive. You see, separation of powers seeks to avoid what we have today. And so the concept of separation of powers that is embodied in the Constitution, to me, is failing now. Because some judges just think that they must exercise power and not reason.
So you see an exercise of power by the judges?
Clearly. No doubt about that. It's an exercise of power. But even the power is being exercised beyond the constitutional limitation. And every lawyer knows that. They are exercising the power. And you see, I was shocked to hear from the Attorney General that the Supreme Court or the Constitution is what the Supreme Court says it is. So which means that to him, if the Supreme Court gets up this morning and say the Constitution is no longer supreme, or the provision of the Constitution that says the Constitution is the supreme law of the land and any other law inconsistent with the Constitution will be to the extent of that inconsistency void. It's not the case. The Supreme Court can get up and say that. So which means that whatever the Supreme Court says about the Constitution, that's what is. No. I was so shocked. But I don't know how to put it, but I can tell you that we have chosen a path that can lead us right into the abyss. Because we are putting a lot of power into irresponsible and incompetent hands. To be at the Supreme Court requires a lot of jurisprudence, deep thinking, have limited, very limited thinking, scope of thinking within our judiciary. And if you ask me how to, it's really, really, really unfortunate. But let me exercise some restraint here, because we are here to receive the ruling and see the reasons based on which they took the decision.
But based on the argument you've made already, will the reasons make any difference for you? Because you're suggesting that they shouldn't have even entertained the matter in the first place.
Yes, and they know that. You see, our earlier discussion, I made you aware that this is not the first time the jurisdiction on the Article 99 has come before the Supreme Court. It has come long before, and you see, the MPP has made it a point that any time the law comes up for contest, they twist it in their own favor. 99 did not come up today. I told you it came up at the time it was J.H. Mensah's 10. J.H. Mensah was a member of the MPP, and because the states were in his favor, they said they didn't have jurisdiction, because 99 has given that jurisdiction to the High Court. And that decision is still here with us. So why would Article 99, the same Article 99, give jurisdiction to the High Court and you still assume jurisdiction? But you see, the Supreme Court is battling with two things. Let me declare. The Supreme Court is battling with one confusion. It seems they are finding it difficult to identify when to apply the law, when we can say the law is applied, and when to say there is a need for constitutional interpretation. It is not all the time that someone comes to you to seek declaration that a constitutional interpretation arises. And so the Constitution has made it clear. Where it is interpretation of the Constitution, it is the exclusive jurisdiction of the Supreme Court. But where it is application of the Constitution, everybody has a duty to apply it. And the Supreme Court says it before, in many other cases, that as we walk daily, we apply the Constitution to our lives. As institutions of government work daily, they work in accordance with the Constitution. They apply it. Now, the simple difference between interpretation and application of the law is not difficult to decipher. If you have to decide whether a state of fact or whether a conduct is inconsistent or constitutes a violation of the Constitution, that is enforcement of the Constitution, not interpretation. If you have to decide that, okay, a state of fact exists, and you want to compare it with the conditions in the provision of the Constitution to see if it is inconsistent or contravenes that provision, that is application of the Constitution. Interpretation comes when there is absurdity in the application of the ordinary meaning of the Constitution. That's number one. When the provision itself, as the constitutional provision, is not clear, and the unclarity or the ambiguity of it might be because another provision of the Constitution is making another provision that conflicts with it. And so the Supreme Court itself has laid down the conditions for interpretation so clearly that one, when the constitutional provision is not clear or ambiguous. Two, when two or more provisions of the Constitution itself are conflicting in meaning. Three, when institutions of government are conflicting in their authority conferred by the Constitution. And four, if two persons give two rival meanings to a provision of the Constitution in a judicial process, and this is what they always confuse themselves with. To say that when two people give two different meanings to the Constitution doesn't mean that if you and I get up and argue, or you decide to give any absurd meaning to the Constitution against the ordinary meaning, then it means a constitutional issue arises. No. It is contemplating a situation where the provision is capable of more than one reasonable meaning. So one is contesting a meaning which is reasonable, and another is contesting another meaning which is also reasonable within the context of the Constitution. That is where an interpretation strikes. But when it comes to enforcement, the Constitution is clear that the Supreme Court has exclusive jurisdiction in both enforcement and interpretation. By which, when it comes to enforcement, when it takes certain provisions, the enforcement of certain provisions, and confer that on other courts, the Supreme Court no longer has exclusive jurisdiction to enforce. But what I want to let you know that is that this is an enforcement of the Constitution that they have done. There was no need for interpretation. It's an enforcement. And if you look at the release of the part, they are seeking declaration. We want you to declare that this is this or this is not this. And Article 99 is so clear. It said when it comes to declaration, a question or a determination whether a seat in Parliament is vacant, it says the High Court shall decide that. And it's not everything the Supreme Court can do. So once the Constitution has given the enforcement of a particular provision of the Constitution to another court, it falls out of the exclusive jurisdiction of the Supreme Court. So you can now not declare that a seat is vacant or not when the Constitution says it is the High Court which will make that declaration. You see?
I see.
Yes, so they know that they were making a declaration, and that declaration is not within their jurisdiction. But you see, when you do that to the Constitution, when you are the ones to be protecting the Constitution, it gives us a cause for alarm. It's unfortunate.
But like the speaker suggests, in fact, the speaker at this press conference, one of the things he said was that the Supreme Court can give an interpretation for a purpose and later change its mind. That's possible, right?
But that is possible, you see. But the same Constitution has prevented capriciousness in the exercise of discretion. You know what that means? To be capricious is to be arbitrary. You see, arbitrary. You are not governing the exercise of your discretion with any principle. You are governing or you are exercising the discretion based on your own whims and caprices. That is not what is intended. Of course, I said earlier that Article 1293 has given the Supreme Court the power to depart from its own previous decision if it appears right. If it appears to it right to do so. There's no doubt about that. But the Constitution also said that until that is done, the Supreme Court should treat those previous decisions as normally binding on them. What does that mean? So before you can communicate to us that those your previous decisions are no longer binding on you, you have to make reference to those decisions and give us cogent reasons why you are departing from that. Otherwise, the exercise of that discretion to depart from your previous decision will be exercised capriciously and arbitrarily, which in itself is against another constitutional provision, 296. Article 296 does not permit arbitrary and capricious exercise of discretion. And if you have to always depart when it suits you, or when it's arbitrary, it's capricious. And that's why I'm saying that we are waiting to see the decision, the ruling, to see why they have taken that decision. Because we know that in their previous decisions, they have stated clearly that they don't have jurisdiction that are granted to the High Court under Article 99. They will not exercise those jurisdictions. And they have given us two principles, which I stated the last time I engaged with you. You see? So, if today, you are saying the same jurisdiction that was given to the High Court, now you will usurp it and exercise it. You have to tell us why. You have to tell us why you are departing from that previous decision. Otherwise, we will not have rule of law. We will not be having rule of persons, rule of Supreme Court judges. That's not what we want. The Constitution doesn't intend any judicial tyranny for the people of Ghana.
I see.
And that is why they themselves are limited by the Constitution itself. So if you say, okay, you can depart from your previous decision, you have to give us a reason. So we need to see the decision and decide whether the reasons they have given for departure are right, or whether they have given such reasons at all.
Now, and I'm hoping to have a discussion with you subsequent to you seeing the reasons given by the Supreme Court.
That's fine.
Yeah, but thank you very much for speaking to us, and extend our greetings to your little one there.
Most welcome.
Yeah. Well, that is lawyer Alhassan Osman, who's been speaking to us. In fact, after the reasons are released later today, maybe on Friday, we'll spend some time with a few lawyers on what they make of what the Supreme Court would have said. By the meantime, you know Dr. Namo Baneke.
Yeah, Dr. Namo Baneke.
Okay, he's now Doctor. So when you're mentioning his name, Dr. Namo Baneke. He says, good morning. So per this ruling by the Supreme Court, if any MP crosses carpet about a year or two to the end of their term in Parliament, they can still see to the party caucus and campaign against them